On Tuesday, the Sturgeon Lake Cree Nation appeared in Edmonton Court of King's Bench, seeking the injunction to halt the stay of Free Alberta petition, urging the province to leave Canada. The community alleges that the independence push violates Treaty 8 rights, claiming it was never consulted and never made the treaty with Alberta, nor did they consent to Canada's creation of Alberta in 1905.
The Alberta Court of King's Bench opened a high-stakes hearing today on an urgent injunction sought by First Nations to halt the province's separatist drive. At the center is a statement of claim filed January 2nd, 2026, by the Sturgeon Lake Cree Nation against the Province of Alberta, the Chief Electoral Officer and the Government of Canada, alleging that the Chief Electoral Officer's approval of a citizen-initiated separation petition violates Treaty 8, which requires First Nations consent before Alberta can leave Confederation. Chief Sheldon Sunshine signed the press release that framed the petition as blatantly unconstitutional and warned of economic and legal harms if the signature gathering proceeds. The Sturgeon Lake filing is not alone. 3 other treaty nations, the Siksika Nation, Piikani Nation, and Blood Tribe, lodged a separate judicial review in Edmonton, arguing the province failed its constitutional duty to consult Indigenous peoples under Section 35 of the Constitution Act, 1982. The Confederacy of Treaty 6 First Nations publicly applauded an earlier ruling by Justice Colin Feasby, who found that the original separation question was unconstitutional because it ignored treaty rights. Legal commentary has sharpened the point. An analysis by Althuis Claire Townsend concluded that the independence proposal contravenes treaties with Alberta First Nations and runs afoul of the Supreme Court's secession reference, which demands clear federal and Indigenous consent for any provincial secession. Media coverage has echoed the treaty argument, noting that First Nations say the independence bid violates Treaty 8 rights and that the court challenge could stop the referendum before signature thresholds are met. Inside the courtroom, lawyers for the nations are asking the judge to issue an interim injunction that would freeze the petition process, preventing the Chief Electoral Officer from validating signatures until the underlying treaty and constitutional questions are decided. The province, led by Premier Danielle Smith, maintains it respects treaty rights while supporting a sovereign Alberta within a united Canada, but the hearing will test whether a province can advance a separation vote without First Nations consent.